Good morning. Please be seated. The sitting is open, and I invite Professor Crawford to continue in his pleading, which he started yesterday. You have the floor, sir.
Thank you, Mr. President. Yesterday I outlined our real case in relation to the temporal aspects of the Convention and illustrated some of the difficulties of Serbia's case. I turn now to the argument Serbia has raised that the Convention is incapable of having effect before its entry into force to the parties to this case, even in a situation of gradual dissolution. In doing so, it is necessary to distinguish between the application of the Convention as such, that is, its substantive provisions, and the application of the dispute settlement provision, Article 9. I turn to the substantive application of the Convention. This is the first and most important question at stake, since, as I will demonstrate, if the Convention applied substantively before that date in relation to the parties, there's very little difficulty in applying Article 9. Professor Zimmerman claimed that he already decided at the preliminary objection stage that Serbia only became bound by the Convention as of April 1992. The word only was an addition by Professor Zimmerman. Of course, if you had said only, that would have ended the question, but you didn't. You decided that Serbia became bound by the Convention from that date onwards, but you expressly left open for consideration at the merits stage the question of the applicability of the obligations under the Genocide Convention to the FRY before 27 April 1992. End of quotation. Turning to that question, let me first analyse the position that the FRY itself took at the time. The best evidence is its own declaration of 27 April 1992, in which it said as follows, and I quote, "The Federal Republic of Yugoslavia, continuing the state, international, legal and political personality of the Socialist Federal Republic of Yugoslavia, shall strictly abide by all the commitments of the SFRY of Yugoslavia assumed internationally." In its official note to the United Nations on the same date, it said, and I quote, "Strictly respecting the continuity of the international personality of Yugoslavia, the Federal Republic of Yugoslavia shall continue to fulfil all the rights conferred to and obligations assumed by the Socialist Federal Republic of Yugoslavia in international relations, including its membership in all international organisations and participation in international treaties ratified or acceded to by Yugoslavia." Now, it's true that in some respects that proclamation was falsified by events, but it was operative at the time. And at the time, Serbia relied on it and was accepted for various purposes, including as a litigant before this court. You previously concluded, and I quote, that the FRY was bound in respect of all the multilateral conventions to which the SFRY had been a party at the time of its dissolution. End of quotation. But in fact, the two documents of April 1992 are framed in even wider terms. They refer to all the obligations assumed by the SFRY, including its participation in international treaties. It's obvious that the FRY itself took the position that the substantive obligations of the Genocide Convention, like all other obligations assumed by the SFRY, continue to apply without any kind of temporal break. The phrase, quote, "obligations in international relations," end of quote, is wide enough to cover secondary obligations of responsibility, a matter to which I will return. And this is the FRY. Mr. President, members of the Court, as a matter of principle, the continued substantive application of the Genocide Convention should not be conditioned on proof of recognition or acquiescence by a successor state. It's true that the Convention can be denounced every 10 years with 6 months' notice under Article 14. But no state has ever denounced it, and a successor state should be presumed not to have done so or to have performed acts having equivalent effect tacitly. In fact, at relevant times, Serbia never expressed any attitude other than continuity. All the obligations assumed by the Socialist Federal Republic of Yugoslavia in international relations, including participation in international treaties ratified or acceded to by Yugoslavia. It cannot be more explicit than that. More fundamentally, however, the Genocide Convention is not just a promise by existing states to do or not to do something. It's a recognition by the international community of states as a whole that genocide is not only a crime of individuals, but also a fundamentally illegal act by whomever committed. You saw this point in Bosnia when you implied into the Convention an obligation of states not themselves to commit genocide. On this basis, Serbians, including Serbian officials, could not have been freed to commit genocide, contrary to the Convention, merely because some equivocation as to its continued application. But there was no such equivocation. And the point is more fundamental still, another layer. The international community of states is not a numerus clausus. It's not limited to the states that happen to exist at a given time. When the international community of states, in the white heat of a post-Holocaust world, at the same time defines and declares certain conduct to be already criminal, contrary to the moral law. How often has the General Assembly referred to the moral law? It is not for this court, I say this with all due respect, to act as a moral skeptic. The object and purpose of the Convention is too important for that. For example, would Srebrenica have been lawful under the Convention or not unlawful if it had happened earlier, before Bosnia and Herzegovina had been established or admitted to the United Nations? Could this court really incite the Milosevic's of this world to early genocidal action in the context of dissolving states? Perish the thought as we look around the world today. I turn then to the application of Article 9 of the Convention. On the assumption that the substantive provisions of the Convention were enforced for all public and private entities located in the SFRY in 1991 and early 1992, and who can gainsay that? The argument that Article 9 should be interpreted as applying to acts of responsibility then arising is a straightforward one. The only temporal requirement expressed in Article 9 is that there be a dispute between the contracting parties relating to the interpretation, application or fulfilment of the Convention. The natural interpretation of these words is that they impose two, and only two, requirements. The dispute should, at the time of its submission to the court, be a dispute between contracting parties, and the dispute should meet the description in Article 9. There is no warrant for reading into Article 9 additional requirements, such as that the applicant state must have been in existence as such at the time the genocide was committed. Serbian counsel relied on a dictum of Judge Fitzmaurice in northern Cameroons as authority for that proposition. But the court decided the case on quite different grounds. On the Fitzmaurice view, a state could not complain of events directly affecting it prior to its creation. The genocide of its own people during the struggle for independence, for example. Such a finding would be entirely gratuitous, and it would be contrary to your decision in the phosphate lands in Nauru case, the first time I stood at this bar, I might say. The tabulated legalism of Fitzmaurice is a fundamentally unsatisfactory way of looking at obligations erga omnes, as you effectively admitted in Barcelona Traction, an admission made at the first opportunity after the Fitzmaurice-inspired debacle of Second Southwest Africa. I was criticised by counsel for citing Mavromatis for the principle that, and I quote, "In cases of doubt, jurisdiction based on an international agreement embraces all disputes referred to the court after its establishment." End of quotation. You were told that the case depended on the words of the specific treaty in question and did not stand for any general proposition. But the principle is well established and is not unique to Mavromatis. I might have taken you, for example, to phosphates in Morocco, where the Permanent Court found that a limitation ratione temporis had been inserted into a treaty, quote, with the object of depriving the acceptance of the compulsory jurisdiction of any retroactive effects, end of quotation. In other words, it was assumed by the court that it would have had jurisdiction but for a limitation on jurisdiction expressly inserted into the relevant text. I previously observed that the principle is recognised in the literature, for example, by no less an authority than Rosen. Paul Tavernier, citing both Mavromatis and phosphates in Morocco, puts it thus: Une limitation ratione temporis devra être expressément prévue dans l'acte attributif de compétence, et elle sera interprétée restrictivement. He adds, l'arrêt Mavromatis a donc énoncé une règle juste à notre avis, car il faut bien distinguer les problèmes de fond des problèmes de procédure, in which he includes jurisdiction. Problems of substance must be distinguished from problems of procedure. There is no contradiction between this principle and the principle of non-retroactivity recognised in Article 28 of the Vienna Convention. Under Article 36, paragraphs 2 to 3 of the statute of the court, a state can accept your jurisdiction compulsorily and can do so unconditionally or on condition of reciprocity or for a certain time. There is no inference of non-retroactivity of the scope of any obligation to accept your jurisdiction when the title of jurisdiction is silent on the point. Professor Tams then told you that the principle no longer applies. That's not so. The Mavromatis principle finds expression in your decision in Bosnia that, and I quote, the Genocide Convention, and in particular Article 9, does not contain any clause the object of or effect of which is to limit in such manner the scope of its jurisdiction ratione temporis. And you hold you had jurisdiction to give effect to Article 9 with regard to the relevant facts that have occurred since the beginning of the conflict which took place in Bosnia and Herzegovina, and that this was in accordance with the object and purpose of the Convention as defined by the Court in 1951. This was despite Serbia's arguments in that case based on non-retroactivity. Eric Bjorga has described Bosnia as a, quote, an application of the rule relating to jurisdictional clauses enunciated in Mavromatis, end of quote. True, you later clarified that you were not addressing whether the relevant facts included facts occurring prior to the coming into existence of the FRY, end of quotation. But that does not detract from the general principle underlying your Bosnia decision and articulated in Mavromatis. Quote, in cases of doubt, jurisdiction based on an international agreement embraces all disputes referred to you after its establishment. The principle applies here. As proof that the court has, as he put it, overruled Mavromatis, Professor Tams directed you to Georgia and Russia, but that case did not deal with the point. Professor Tams told you that Georgia sought to rely on facts predating 1999, the time when it became bound by the Convention on the Elimination of Racial Discrimination. But the context of the passage he cited was quite specific. Russia had objected to jurisdiction on the ground, and I quote, that there was no dispute between the parties regarding the interpretation or application of CERD at the date Georgia filed its application. Now that objection, if sustained, would have been fatal. In the passage cited, Georgia was invoking evidence from before 1999, not to refute the objection directly, but in order to establish that the dispute was long-standing and legitimate and not of recent invention, end of quote. What you held is that Georgia had not cited evidence from before 1999 establishing that point. You added that even if it had, that dispute, though about racial discrimination, could not have been a dispute with respect to the interpretation or application of CERD, the only kind of dispute in respect of which the court is given jurisdiction, end of quote. If Professor Tams had extracted from this passage the principle that states cannot be in dispute under a treaty while it's not in force between them, that might have been arguable. although I've already said that in any case the declaratory character of the Genocide Convention should lead to a different result. But he relies on the passage for a different proposition. He claims that you made it very clear that both parties had to be bound by CERD when the disputed conduct took place, and not, as Croatia argues, when the case was brought. But you did not say that in Georgia and Russia, or anything that can be construed to being to that effect. On the contrary, you said at the beginning of your discussion that, and I quote, "The dispute must in principle exist at the time the application is submitted to the court." End of quotation. That is, with respect, absolutely correct, and that requirement is fulfilled here. It is not in doubt that there was a dispute at the time Croatia filed its application. Nor can the distinction between treaty and customary international law take Serbia anywhere. Croatia has referred to the customary prohibition of genocide to establish the object and purpose of the Convention and the temporal scope of the substantive obligations contained in it. But Georgia's submission is that the Convention applies in this case. The passage from Georgia and Russia about the existence and characterization of the dispute at the time the application was filed is irrelevant to this question. Russia made a separate objection in Georgia-Russia, and I quote, that any jurisdiction the court might have is limited rationale temporis to the events that occurred after the entry into force of CERD as between the parties. End of quotation. Now, that objection is much more comparable to the point at issue here. But you found that having upheld one of Russia's objections, you were not required to consider that further objection. So it's something of a stretch to present your argument as having overruled Mavromatis on a point which you expressly and unambiguously declined to consider. Georgia and Russia was also cited for a further proposition. Professor Zimmerman, on this occasion appearing with Professor Tamsin, not in parallel, observed that the possibility of automatic succession was not even argued or even considered in the case. He then concludes that you rejected it. Mr. President, members of the Court, if Georgia and Russia is taken as authority against every proposition that was neither argued nor considered, you don't really have to consider any more cases. The development of your jurisprudence is complete. But such an argument would have the effect of crippling humanitarian treaties in relation to situations of conflict and dissolution, and of doing so at a time of ethnic violence. I cannot believe that this effect is desired. It is certainly not desirable. It would sideline the court, and it would make it less rather than more relevant in our unstable world. The other case heavily relied on by Serbia was Belgium and Senegal. They said I didn't refer to it, I think on at least 5 occasions. Several passages were cited. The first, once again, deals with the analytically distinct question whether there was a dispute at the time the application was filed. All you observe in this passage is that at the time Belgium filed its application, there was no dispute concerning a particular customary obligation that Senegal allegedly breached, as distinct from obligations under the Convention Against Torture. Serbia cites this for the rather banal proposition that the issue of whether a customary obligation exists is distinct from compliance with a treaty obligation. The passage has no other relevance for our case. Professor Zimmerman told you that Belgium and Senegal also supports the proposition that Croatia has no standing to request the court to rule on Serbia's compliance with obligations before Croatia came into existence. But again, the passage has been quoted out of context. What Senegal actually argued was that the obligation in issue, and I quote, belongs to the category of divisible erga omnes obligations, end of quote, in that only the injured state could call for its breach to be sanctioned. The obligations in the Genocide Convention, notably the obligation not to commit genocide, are not divisible erga omnes obligations. Genocide is not relevant to any individual state, relative to any individual state. It's relevant but not relative. Moreover, you went on to note that Belgium had standing from the date it became a party to the Convention in 1999, and that it had invoked Senegal's responsibility starting in the year 2000. So again, it can hardly be said that you decided the point. Finally, Council referred you to Belgium and Senegal for your analysis of the temporal scope of Article 7.1 of the Convention Against Torture. That provision requires states to prosecute or extradite certain offenders. Now, that Article 7.1 is not about the compromissory clause. It's got nothing to do with the presumption in Mavromatis that jurisdiction under a compromissory clause embraces all disputes referred to the court after its establishment. Secondly, you distinguish the obligation to prosecute or extradite from the prohibition of torture use itself. You said, and I quote, "The prohibition of torture is part of customary international law and it has become a peremptory norm, jus cogens." End of quotation. You say this apparently by way of contrast with the obligation to prosecute or extradite, which you conclude by reference to Article 28 of the Vienna Convention, applies only to facts having occurred after its entry into force for the state concerned, end of quotation. Your discussion was not directed to the temporal scope of the prohibition of torture per se. So even taken at its highest, the discussion in Belgium and Senegal is relevant only to the one specific jurisdictional issue, the temporal scope of substantive obligations analogous to the obligation to prosecute or extradite under the Convention Against Torture. That analogy is not opposite here. We should look at the approach of the European Court of Human Rights. Despite the well-established proposition that the Convention as such is only prospective in effect. In Chile and Slovenia, the question was whether the Convention could apply to facts occurring before Slovenia acceded to it. The obligation in issue was analogous to the obligation to punish under the Genocide Convention or the obligation to extradite under the Torture Convention. The Court held, and I quote, "The procedural obligation to carry out an effective investigation under Article 2 has evolved into a separate and autonomous duty. Although it is triggered by the acts concerning the substantive aspects of Article 2, it can give rise to a finding of a separate and independent interference within the meaning of the Blesic judgment. In this sense, it can be considered to be a detachable obligation arising out of Article 2, capable of binding the state, even when the death took place before the relevant date." That's in respect of a prospective convention. But let me leave analogies aside and quote Article 1 of the Genocide Convention. The contracting parties confirm that genocide, whether committed in time of peace or in time of war, is a crime under international law which they undertake to prevent and to punish. They confirm that it is a crime. They undertake to punish it. General Assembly Resolution 96-1 similarly affirmed that genocide is a crime under international law. The confirmatory, declaratory expression of the Convention, unique in this respect amongst modern treaties, the expression of a potent and widely held moral outrage at past events, they're powerful indications that the Convention lacks the temporal limitations found in other treaties. This was not the case with CERD, which was at issue in Georgia, Russia, nor was it the case with the Convention Against Torture at issue in Belgium, Senegal. Previous to the Convention Against Torture, a single act of state court torture would no doubt have been a breach of human rights, but it was only criminal under international law if it was part of an attack on a civilian population, a crime against humanity or a war crime. It was made per se unlawful in 1984. In terms, both treaties made new law. I've already emphasised the different character of the Genocide Convention, which did purport to codify an existing crime. Who at the time would have said that genocide as it had occurred was not a crime? Another analogy with human rights law may also be helpful, even though the Genocide Convention is sui generis. A potential time gap in the application of the multilateral human rights treaty arose in a different context in Bijelic and Montenegro and Serbia. At the time of the application, Montenegro was in a constitutional union with Serbia. After its independence in 3 June 2006, the application indicated that they wished to proceed against both states. The potential time gap arose because it was not until 2007 that Montenegro joined the Council of Europe. The The Committee of Ministers of the Council of Europe decided retroactively that Montenegro could be regarded as a party to the European Convention with effect from 6 June 2006. The European Court had regard to this and to, and I quote, "The principle that fundamental rights protected by international human rights treaties should indeed belong to individuals living in the territory of the state party concerned, notwithstanding its subsequent dissolution or succession." End of quotation. It deemed the Convention, and I quote, "as having been continuously in force in respect of Montenegro," end of quote, as of the date 2004 when the FRY acceded to it. Now, the independence of Montenegro was, of course, very different from the earlier dissolution of the SFRY and the gradual emergence on its territory of new states. You recall that Croatia has maintained these proceedings against Serbia as the continuator state and has not instituted separate proceedings against Montenegro. But the Bjelic case illustrates the importance of the continuity of human rights for the people living in a territory. And we say it's a fortiori for the Genocide Convention. I turn to a third issue, which is succession to responsibility. Serbia suggests that Croatia should have framed its case as one of succession to responsibility. Croatia's primary submission in this respect is that the court must look at the practical reality of the situation. During the events of 1991 and early 1992, the SFRY simply was not functioning as a state. And to hold that only the SFRY could have been responsible for conduct by the JNA would be a legal fiction. As Judge Hudson said it in Lighthouses in Crete and Samos, a juristic conception should not be stretched to the breaking point, and a ghost of a hollow sovereignty cannot be permitted to obscure the realities. SFRY by the end of 1991 was the ghost of a hollow sovereignty. In practical terms, the JNA was now plainly an organ of the nascent Serbian state. This was confirmed after 27 April 1992 when it was effectively transformed into a de jure organ. But if these submissions, that's our principal case, if these submissions are rejected, if the court were to find that the SFRY and only the SFRY was responsible for conduct by the JNA during the relevant period, then a further finding of succession to responsibility is called for. We make that submission in the alternative. The point was also not decided at the preliminary objection stage. You found that Serbia had succeeded to multilateral treaties to which the SFRY was a party, but you made no finding about succession to responsibility. In this regard, we can take some guidance from the Lighthouses arbitration. There, the Cretan Coastal Service had exempted a Greek vessel from payment of light dues in breach of a treaty. Greece was held responsible for this conduct, even though it occurred before Crete was united with Greece in 1913. Among other relevant circumstances, the case had putatively been brought to Greece's attention, and Greece had kept the Coastal Service concession in force after its succession to Crete. Note the parallel here with the JNA. In practice, it was kept in service under a new name after the proclamation of the FRY. Note also that Greece did not make any express declaration of succession to responsibility. Such a declaration is evidently not required where conduct is clear enough in itself. The tribunal held that Greece's responsibility could result, and I quote, only from a transmission of responsibility in accordance with the rules of customary law or the general principles of law regulating the succession of states, end of quote. It recognised the sui generis character of such situations, saying, quote, it is no less unjustifiable to admit the principle of transmission as a general rule than to deny it, end of quotation, and that, quote, the solution must depend on the particular circumstances of each case, end of quotation. So let's look at the circumstances in this case. We say the rule is succession can occur in particular circumstances if it is justified. There is no general rule of succession to responsibility, but there is no general rule against it either. Say that following the proclamation of the FRY on 27 April 1992, someone had asked President Milosevic whether the new FRY was responsible for the conduct of the old SFRY. What would he have said? The answer is obvious and inescapable. At the time, he rigorously maintained the claim of continuity with SFRY. Consistent with this claim, Milosevic or any other official of the new FRY would unquestionably have said yes. The FRY is responsible in international law for all conduct attributable to the SFRY. This conclusion follows inexorably from the FRY's conduct and statements around that time, in particular from the Declaration of 27 April 1992 and the related statement to the United Nations, which reflected the position of the state. The controversy about the status of the FRY between 1992 and 2000 has created some confusion, and to put it mildly, was a source of some difficulty for the court. But in the last analysis, whatever approach the court takes, and whatever effect the change of Serbian policy in relation to the United Nations in 2000 had, the Serbian leadership and state apparatus should not be granted impunity from the international responsibility that they themselves and everyone else believed that they had. Mr. President, members of the Court, one final point on jurisdiction. Serbia argued that Croatia had, and I quote, not referred to any events that took place after 27 April 1992 as allegedly constituting genocidal acts, so that our case is, and I quote, fully dependent on a retroactive application of the Genocide Convention, end of quote. In fact, Croatia's written pleadings refer to many crimes, many wrongful acts committed after 27 April 1992 as evidence of the continuing genocidal campaign against the Croatian population. In May 1992, for example, Croat residents were forcibly exiled from Berak and then forced to walk over a minefield. In February 1993, members of a Serbian paramilitary group, led by an active officer of what was then the de jure army of the FRY, murdered Croats in Pulane. As a result of the massacre, the remaining inhabitants of Pulane fled the following day. The only punishment the murderers received was dismissal from their units. Between May 1992 and February 1993, Croat civilians were massacred in Medveda and their killers released without charge. Further examples are contained in the footnotes. In any event, it seems that Serbia has changed its position. It conceded last week that at least 8 alleged acts of genocide did occur after 27 April 1992. So in the further alternative, if the court holds that the convention was applicable only from 27 April 1992, there are still acts you need to deal with. It does not let the court, if I can say so with the greatest respect, off the hook. In any event, Serbia has a continuing responsibility for breaches of the Genocide Convention. The failure to punish acts of genocide is ongoing, irrespective of whether those acts occurred before or after 27 April 1992. This is consistent with Article 14, paragraph 2 of the Articles on State Responsibility, which provides, and I quote, "The breach of an international obligation by an act of a state having a continuing character extends over the entire period during which an act continues and remains not in conformity with the international obligation," end of quote. You've heard from Professor Sands that the families whose loved ones have not been accounted for, the disappeared of Croatia, continue to be subject to serious mental harm in breach of Article 2 of the Convention. The causing of such harm is widely recognised as a violation having a continuing character. The United Nations Declaration on the Protection of Persons from Enforced Disappearances states, and I quote, "Acts constituting enforced disappearances shall be considered a continuing offence as long as the perpetrators continue to conceal the fate and the whereabouts of persons who have disappeared, and these facts remain unclarified." This was confirmed by the Inter-American Court in one of its most important decisions, Velasquez-Rodriguez, where it said, and I quote, "The duty to investigate facts of this type continues as long as there is uncertainty about the fate of the person who has disappeared. Even in the hypothetical case that those individually responsible for crimes of this type cannot be legally punished under certain circumstances, the state is obligated to use the means at its disposal to inform the relatives of the fate of the victims and if they have been killed at the location of their remains." End of quotation. The same reasoning applies to Article 2 of the Genocide Convention, which provides that the actus reus of genocide includes, and I quote, "causing serious bodily or mental harm to members of the group," end of quote. So again, Serbia is responsible for such continuing breaches of Article 2, irrespective of its submission on jurisdiction over events before 27 April 1992. Mr. President, members of the Court, that concludes my remarks on jurisdiction. I move now to the question of attribution, beginning with the applicability of Article 10, paragraph 2 of the Articles on State Responsibility. That may not have been famous before this case, it will be famous now. Here Serbia repeated a number of arguments from its written pleadings, which we rebutted in the first round without dealing with that rebuttal. For example, counsel for Serbia repeatedly referred to what it called movement responsibility. Rather curious phrase. But as I said in the first round, Article 10.2 is not concerned with the responsibilities of a movement, qua movement, but with the responsibility of a movement, qua state in embryo. Article 10.2 is not limited to substantive obligations that apply specifically to movements, whether or not they are successful, such as obligations accepted by declaration under Additional Protocol 1 of the Geneva Conventions. It follows from this clear and straightforward proposition that other relevant rules of attribution apply in as much the same way as they otherwise would in a situation where Article 10.2 applies. Mr. Lukic claimed that there can be no equivalent to Article 8 in the context of movement responsibility, and that the ILC commentary, and I quote, "expressly excluded conduct of individual members of the movement," end of quote. It did no such thing. A movement, like a state, can act only through its officials or other human individuals. It's not a mythological creature with its own hands and feet. The commentary cited states that Article 10.2 covers, and I quote, "conduct of the movement as such, and not the individual acts of the members of the movement acting in their own capacity," end of quote. Exactly the same proposition applies to Article 4 and to Article 7. Members of the JNA were not acting in their own capacity. They were acting in their capacity as members of the JNA, a de facto organ of the nascent Serbian state. The usual principles of attribution apply. Professor Tams argued that a movement under Article 10.2 cannot be aligned to the interests of the state against which it is fighting, and yet said that I, quote, "emphasise the alignment between the alleged Greater Serbia movement and the SFRY," end of quote. That's a distortion of what I said. I used these words, quote, "the alignment of objectives between the JNA and the Serbian leadership," end of quote. I then referred to the contempt and disregard of the JNA command for the Constitution and the SFRY presidency. I quoted a series of phrases about that contempt, about the transparent device of using the JNA as a real Serbian organ rather than an apparent SFRY one. To none of those quotations was there any response. What I said was the opposite of what Professor Tams claims. The movement in question was led by Serbian political and military leaders in a joint criminal enterprise, so found, whose objectives included a Greater Serbia. That was the movement, and it certainly was aligned against the interests of the SFRY. It rendered the SFRY presidency effectively impotent. It took de facto control of state organs such as the JNA, which it employed for its own political and military objectives. It even attacked a building where the head of state and the head of government of the SFR were inside. That's a curious form of alignment. Perhaps the missile was aligned. Professor Tams advised you to look at the map for proof that this movement did not succeed in establishing a Greater Serbia. Well, it eventually didn't succeed. Anyone who looked at the map between 1992 and 1995, when Serbian and Serb forces occupied some 1/3 of Croatia and more than 2/3 of Bosnia-Herzegovina, would have drawn a different conclusion. If the conduct was attributable in 1994, it didn't cease to be attributable later on because of the defeat of Serbian objectives. The fact is that the movement did succeed in establishing a new state, even if it wasn't the state that Milosevic wanted. Those are the words of Article 10.2. It's the only type of success required. It's a modified success, but not everyone has their own state. The fact that it didn't achieve the full extent of its territorial ambitions cannot relieve it of responsibility for what it actually did. Serbia argued that state practice on Article 10.2 is sparse, as if sparseness in itself could justify the court in departing from the principle. Yet Serbia has not pointed to any authority credibly denying the existence of the principle. Nor is it decisive that there was no exact precedent for the sui generis situation now before this court. As this court knows only too well, principles of international law must constantly be applied to newly arising situations, whether by way of analogy or where a situation falls squarely within a general principle that has previously been applied to a range of other sui generis situations. An example is the conduct of the Polish National Committee for the recognition of the new Polish state in 1919. This was cited during the drafting of what is now Article 10, paragraph 2, in support of the proposition that despite the sparseness of state practice, the rule seems well established. Another application of the rule to sui generis circumstances is the case of Algeria. The movement in question, the FLN, achieved independence for Algeria in 1962. The Evian Accords between France and the provisional government included a declaration that Algeria assumes the obligation and benefits from the rights contracted in its name and those of Algerian public establishments by the competent French authorities. Algeria assumed the obligations and benefited from the rights contracted in its name by France. The situation was in some respects comparable to Serbia's succession to the Genocide Convention, consistent with its acceptance to be bound by all its international obligations. Now, it's true that Algeria never formally complied with this declaration with respect to the actions of the FLN before its formal independence. But French courts in a series of cases have interpreted it to apply to those actions. Patrick Dumbury observes of the Grillo case in 1999 that it seems that the Conseil d'État interpreted the international wrongful acts committed before the independence of Algeria as those of the future state of Algeria, end of quote. That's the statu nascendi rule. It's a necessary construction dealing with the fact that states don't come into existence in situations of belligerency at a single moment in time. In the Perriquet case in 1995, the Conseil d'État was concerned with any potential French responsibility and so did not make an actual finding against Algeria. But its view is expressed clearly enough. It observed that as a result of the declaration, rights and obligations contracted by France in the name of Algeria had been transferred to the Algerian state on independence. It then said, and I quote, "L'indemnisation des dommages imputables à des éléments insurrectionnels intéresse l'État algérien." End of quotation. I do not suggest, Mr. President, members of the Court, that the present situation is precisely the same as the ones I've suggested, the ones I've dealt with, the Polish National Committee, the FLN, or other previous situations where the principle recognised in Article 10, paragraph 2 has applied. It's not the same, we can point to differences. But those past situations are further evidence that the assertion that Article 10.2 represents a new rule and is limited to movements of some very specific type cannot be justified. This is a situation of the same general configuration, the same general principle of attribution applies, and for the same reasons. As Patrick Dumbury, who studied this subject in some detail, says, and I quote, "The new state should remain responsible for acts that took place before its independence because there is a structural and organic continuity of the legal personality of what was then a rebel movement, in this case an other movement, where all the relevant with all the relevant characteristics that has since successfully become a new independent state. In our case, the structural and organic continuity between the Serbian military and political leadership and the FRY was complete." In this context, I should say a word after all these years, about the work of the ILC on attribution, notably Article 10. The fact that the actual language of Article 10.2 was adopted on second reading does not preclude it from being judged to be customary international law. The ILC's function is not simply to record practice and to adopt sparse articles where the practice is sparse. Some of the ILC articles have been criticised for being sparse, but that's not a very good reason for sparseness. The ILC's function is to rationalise the law and to expose its underlying structure and values for international scrutiny, not least scrutiny by this court. Anyone looking at the jurisprudence of continuity in contexts such as those covered by Article 10 will be struck by the consistent tendency of courts and tribunals to maintain continuity. Lighthouses in Crete and Samos, the Lighthouses arbitration, are but two examples. Mr. President, members of the Court, moving away from Article 10, paragraph 2, perhaps slightly reluctantly, I should mention some other elements of Croatia's argument on attribution. It may assist the Court if I summarise again the various grounds on which we say the conduct is attributable to Serbia, since Serbia did not respond to all of our arguments and since it accused us of attempting to sow confusion about which grounds applied. First, Serbia's failure to prevent and punish acts of genocide amount in themselves to breaches of the Genocide Convention. In addition, Serbia's failure to assist with locating disappeared persons constitutes a continuing breach of Article 2. These breaches are self-evidently attributable to Serbia. Secondly, the facts confirmed in numerous findings of the ICTY demonstrate that the JNA directly committed acts which we say amounted to genocide. That ultimate judgment of characterisation is for you. The acts themselves are established. It also ordered, facilitated, aided, abetted and otherwise supported the commission of genocide by other Serb forces of which the JNA had actual knowledge. This includes acts by the forces of the self-proclaimed Serb entities in Croatia and by Serb paramilitaries. Insofar as the conduct of the JNA itself amounts to acts of genocide or to complicity in acts of genocide, all that we're required to establish is that the conduct is attributable to Serbia. We've done this by reference primarily to Article 4 and to the jurisprudence of the Court on when an entity can be treated as a de facto organ. The JNA was a de facto organ of the emergent Serbian state. I've explained why these principles are capable of applying in a situation where a state is in statu nascendi in the same way, essentially, as they apply to other cases of state responsibility. Croatia also suggested that conduct by the JNA may be attributable to Serbia under Article 8 on direction and control, but the primary ground on which we say it's attributable is Article 4. Serbia's refrain that the JNA was de jure an organ of the SFRY is simply irrelevant. Of course it was a de jure an organ of the SFRY. But I repeat the test you applied in Bosnia, and I quote, "Persons, groups or entities may, for the purposes of international responsibility, be equated with state organs even if that status does not follow from internal law, provided that in fact the persons, groups or entities act in complete dependence on the state, of which they are ultimately merely the instruments." Serbia responded to this by citing animosity between Kadijevic and Milosevic, and arguing that neither influence nor control could exist in such a relationship. It also asserted that we provided no evidence of direct orders. Mr. President, members of the Court, we're not required to provide evidence of direct orders. States are responsible for genocide even if they keep the orders tacit or silent. If the genocide is proved, there is no need for a 1C conference. If an entity can be equated with a state organ, the state is responsible for all conduct by that entity, as with any other conduct of the state. Whether the Serbian political and military leaders liked each other or not is neither here nor there. They were party to a joint criminal enterprise whose, and I quote, "common purpose was the establishment of an ethnically Serb territory through the displacement of the Croat and other non-Serb population," end of quote. That's from Matic. They were leaders of a movement with that objective, and the JNA was the army of that movement in complete dependence on it. As Kadijevic himself put it, and I quote, "The Serb and Montenegrin people considered the JNA as their army in the same way that they considered the Yugoslav state their country." And he saw the JNA's responsibility as being, and I quote, "to secure for the new Yugoslavia," that is, the FRY, and the entire Serb population wherever located, its own army, end of quote. Let me illustrate where Serbia's approach goes wrong. Mr. Lukic highlighted a comment by the ICTY that the evidence did not establish that Mrksic consulted his superiors in Belgrade about handing over prisoners of war from Vukovar to paramilitary and local SAO forces. It doesn't matter whether he consulted his superiors in Belgrade or not. He was a colonel in the JNA. Under Article 7, the conduct of an organ of the state or of a person or entity empowered to exercise elements of governmental authority is attributable to that state if it acts in that capacity, even if it exceeds its authority or contravenes instructions. Even if Mrksic had acted contrary to instructions from Belgrade, which the respondent would know and has not told us, the responsibility would still exist. A more pertinent question is who the superiors in Belgrade actually were. The ICTY tells us it was not the President of the Presidency. By early 1991, the JNA had come to be typically perceived in Croatia as aligned with Serb interests and effectively commanded from Belgrade by a Serb-dominated leadership. The ICTY later refers to the Serb-controlled federal government in Belgrade. You heard from Serbia that on 6 January 1992, Kadijevic relinquished the duty of the Federal Secretary and Milosevic became the absolute commander of the army. Those are Kadijevic's own words in an interview quoted by Serbia. Of course, we've shown the JNA was a de facto Serbian state organ even before that date. But from that date onwards, we have direct confirmation from Kadijevic that the JNA was following the orders of the Serbian political leadership of Milosevic. That was months before the proclamation of the FRY. It conclusively discredits Serbia's assertion that the JNA continued to function as an organ of the SFRY until the 26th of April 1992. It belies any suggestion that the apparatus of the new Serb state sprang into being instantaneously, like Athena from the head of Zeus, to take a rather inappropriate example, without any period of gestation. In reality, state dissolution and emergence are often gradual. It was the same with the gradual transformation of the JNA from an organ of the old state to an organ of the new. We were criticised by referring to the centralisation of the command structure of the JNA in 1988 and the subsequent Serbianisation of its personnel. These earlier events are relevant as the background to the transformation, to explain how the Serbian military and political leadership was later able to take effective control of the JNA. Serbia accepted that by late 1991, the JNA became an active participant in the conflict in Croatia, though it argued that it was reactive rather than proactive. These events did not arise in a theoretical vacuum. Croatia, of course, has disputed who was active and who was proactive, who was defensive and who was not. But that's not the main point. The main point is that the JNA were acting as an instrument of Serbian political and military policy and not as an organ of the SFRY, whose political institutions had been effectively paralysed or taken over by Serbia. By late 1991, the JNA, under Kadijevic's military leadership, was already a de facto organ of the emergent Serbian state. After January 1992, Milosevic was directly exercising both military and political authority. Finally, there is the third ground on which we argue that conduct is attributable to Serbia. Conduct by other Serb forces breached the Convention directly. We do not maintain that the other Serb forces were themselves organs of the emergent Serbian state. with the sole exception of the territorial defence of Serbia, which Serbia has accepted, and I quote, should be equated to the actions of the JNA and attributed to the JNA, end of quote. Croatia's argument is that conduct by other Serb forces is attributable to Serbia under Article 8, since they operated under the instructions, direction or control of the JNA. Serbia's attack on the Article 8 argument was self-defeating. It quoted the conclusions drawn by the ICTY in Merksic, I'm getting it right these days, aren't I? That, quote, what had been established as the de facto reality in the Serb military operations in Croatia was the complete command and full control by the JNA of more military operations, end of quote. It then showed you some of the evidence leading to that conclusion. The circular of the Chief of General Staff, the order of the Command of the 1st Military District, both of October 1991. These documents, in fact, support the ICTY's conclusion. They comprise some of the evidence because the ICTY said they served to confirm what had been established as the de facto reality, end of quote. The ICTY was satisfied of that on the basis of the totality of the evidence before it. Mr. Ignatovic tried to transmogrify this conclusion into its opposite, but without presenting any direct evidence that the principle of complete command and full control by the JNA of all military operations was not implemented. The ICTY expressly said it was implemented, that it was the de facto reality. The Court lives in the real world. Mr. President, members of the Court, I conclude where my submissions began, with the danger identified by Judge Shahabedin that Serbia's arguments in the Bosnia case and repeated here could lead in one way or another to an inescapable time gap that would undermine the object and purpose of the Genocide Convention, to safeguard the very existence of certain human groups, and to confirm and endorse the most elementary principles of morality. That remains an apt description of where Serbia's arguments in this case would lead. Serbia has quibbled with our arguments on attribution and jurisdiction, and I've shown that its quibbling does not stand up to scrutiny. But Serbia has nothing at all to say on this fundamental point. The word continuity did not pass its lips, despite what it said in 27 April, on which it now relies. However you choose to frame the legal issues in this case, Mr. President, members of the Court, you cannot allow the Genocide Convention to sink into irrelevance in the circumstances of state dissolution where it is most needed, to tremble and retreat before a ghost of a hollow sovereignty. Mr. President, members of the Court, thank you for your attention. I ask you to call upon the agent.
Thank you, Professor Crawford. And I call now on agent Croatia. Madam, you have the floor.
Good morning to you. Thank you, Mr. President, for allowing me now to, first of all, to reply to Judge Greenwood's question asked on the 20th of March. He asked about the on-site witness statements that were attached to the Croatian memorial. And the question was, would statements of that kind be admissible in proceedings in the courts of Croatia? And would they have been admissible in such proceedings at the time that the statements were taken? And the answer provided by Croatia is as follows. The criminal legal system in Croatia is, and was in the early 1990s, based on the civil law, which affords a central role to the investigating judge. It therefore follows a very different approach to the collection of evidence, including witness statements, than that adopted by international courts and tribunals, or indeed courts in common law jurisdictions. Police witness statements or records taken from victims and witnesses are sent together with the police file to the state prosecutor and, if charges are laid, to the investigating judge. There is no requirement that these police statements be signed by the victim or witness. The investigating judge will then decide on the basis of the information before him or her, including the police witness statements, what witnesses he or she wishes to interrogate. Following such interrogation, formal statements are drawn up for each of the witnesses, which are then admissible in a court of law. As such, while the police statements are admitted into the court process and form the basis for the statements admitted in court, they are not themselves admissible in court proceedings in Croatia, and the same applies to non-police statements. The unsigned police witness statements included in the applicant's memorial and addressed by Judge Greenwood's question have been prepared in accordance with the Croatian Criminal Procedure Code in force. They are part of the formal initial stages of a criminal investigation as carried out by the police authorities. Croatia's understanding is that procedures before international courts, including the ICTY and the ICJ, follow a different procedure from that of national legal systems. Its case has been prepared on the basis of the approach taken by such courts in circumstances in which they do not allocate a role for an investigating judge to gather evidence, including witness statements. In any event, as you heard, the additional step has been taken for the purposes of these proceedings of requiring witnesses to sign confirmatory statements indicating that the content of their original statement is true. As highlighted by Ms. Negroli yesterday, this court has accepted witness statements of Croatia's witnesses of fact without following the Croatian procedure. Croatia would be pleased to respond to this question in greater detail if that would be of assistance to the court. Thank you. And now, if you allow me, I will proceed with the closing remarks on behalf of Croatia.
Yes, please proceed, Madam Professor. You have the floor.
Thank you. So, Mr. President, members of the court, over the last few weeks, Croatia addressed the events and circumstances that caused us to come to this court. We have presented you with evidence that the respondent is responsible for the crime of genocide against the Croats living in the area that was intended to be part of a greater Serbia. We have also shown you, by contrast, that there was no crime of genocide committed against the Serbs during or after Operation Storm in August 1995. Croatia submitted its application in 1999, when Mr. Milosevic was still in power in Serbia. Even though he was removed from office in 2000, the change in government did not bring about a change in attitudes regarding the events in Croatia, despite our initial hopes. Denial seems to be the constant in the string of governments in Serbia, resulting in continued and ongoing setbacks in negotiations. We have witnessed similar denials in this courtroom over these last few weeks. Over the years, since the filing of the application, the case law of the ICTY has developed significantly. Through that development, Croatia's claims have been corroborated and substantiated. A number of Serb perpetrators have been found guilty and have been convicted for the most egregious crimes committed against Croatia and its citizens. The ICTY has found the existence of a joint criminal enterprise of the Serbian political and military leadership, which had as its common purpose the establishment of an ethnically Serb territory through the displacement of the non-Serb population. That's a quote from the ICTY. It is true that nobody has ever been charged with genocide, and the respondent seems to give great weight to that fact. It does not seem to be as appreciative of the fact that the Croatian Republic has been charged with genocide. It does not seem to be as appreciative of the fact that the Croatian Republic has been charged with genocide. It does not seem to be as appreciative of the fact that the Croatian Republic has been charged with genocide. that nobody has ever been convicted by the ICTY for any crime against the Serbs in Croatia, let alone crime of genocide that it claims. The reality is that the ICTY judges have never been asked to consider the events we have brought to this court to include genocide, include acts of genocide. You are the first international court or tribunal to address these issues by reference to the crime of genocide. The case law of the ICTY has also contributed greatly in establishing the facts regarding what happened in the region. As this court has put it, its findings are highly persuasive, and the applicant has relied on them as part of its evidence. The ICTY has used extensive resources and time to establish facts in cases that it has examined. However, as Croatia has explained, its findings on the law and the legal characterization of the established crimes cannot serve to provide answers for all the issues which arise before this court. The ICTY deals exclusively with the individual criminal responsibility of the accused. Its view may be narrowly focused as it considers only those crimes that are included in the indictments. The ICTY, unlike this court, has no jurisdiction over states. The applicant looks to this court to take a more all-embracing view of the events from 1991 to 1995, to take them in their totality and in the context of the political situation that prevailed at that time in the aftermath of the fall of the Berlin Wall and communism in Europe, democratic elections in former communist states, and to take account of the new realities that some were not ready to accept. We asked the court to look into the sui generis situation in the specific context of the disintegration of the SFRY and the emergence on its territory of 5 new states amidst great violence and disorder. We asked the court to see the role of extreme Serbian nationalism for what it was, a criminal attempt to create one state for all Serbs by pursuing the project of Greater Serbia through genocidal acts not only in Croatia but also in Bosnia and Herzegovina and Kosovo. As you will have seen yourselves, there are still public officials and others in Serbia who are unwilling to confront the truth about the events that began more than 2 decades ago. For this reason, the past remains present and cannot be consigned to history. As we stated at the beginning of these proceedings, they continue to resonate. The court continues to have an important role in addressing the facts and confirming once and for all that the requirements of the 1948 Convention have been met in relation to Croatia's application and not met in relation to Serbia's counterclaim. The applicant believes that the parties to this case need the judgment of this court to close this chapter and to move forward in their mutual relations. Croatia has moved forward. It is now a member of the European Union after passing through the intensive scrutiny involved in applying for accession to the EU, with its long-established democratic institutions, with a high degree of human rights protection, and with the protection of its minorities, both at national and international level. Serbia apparently wants to do the same. But this may prove to be difficult if it continues down its path of denials and of refusing to confront realities. As I stated at the beginning of oral pleadings, Croatia wishes to achieve full reconciliation with Serbia. We are neighboring countries. We have many ties, human, economic, cultural, and others. But our relations are also burdened by Serbia's refusal to confront its past and resolve the unresolved issues of the 1990s, including Serbia's refusal to accept the judgments of the ICTY and of this court. We look to this court for its assistance in handing down a judgment that will assist our two states to address the past and resolve the issues that continue to divide us. There is an outstanding issue that is particularly painful. This is the issue of missing persons who are missing because of genocidal acts in 1991-1992. Almost 20 years after the cessation of hostilities, there are some 865 Croats missing from that period, with families and friends looking for closure. There are a number of initiatives which aim at resolving their fate, which I described to the court by way of replying to the second part of the question put by Judge Cansado Trindade to the parties on the 14th of March. So the question was, have there been any recent initiatives to identify and to clarify further the fate of the disappeared persons still missing to date? In 1995, in Dayton, Croatia and Serbia concluded an agreement, the purpose of which was to establish the fate of all missing persons and to release the prisoners. As a result of the agreement, a joint commission was established and some progress was made with respect to missing persons. First, from August 1996 till 1998, Croatia was given access to information, the so-called protocols, for 1,063 persons who were buried at the Vukovar New Cemetery, and these protocols helped in the identification of 938 people. In 2001, exhumation started with respect to unidentified bodies buried in the Republic of Serbia at marked grave sites, and thus far the remains of 394 persons have been exhumed, but it is regrettable that only 103 bodies have been handed over to the Republic of Croatia. To date, only one mass grave has been discovered in Croatia with 13 bodies as a result of information provided by Serbia. This was in 2013 in Sotin in eastern Slavonia. Whilst there has been some progress, there are a number of outstanding issues that need to be resolved. Recently, the Commission in Belgrade is once again seeking to act as a representative of all missing persons of Serb ethnicity, including those who are citizens of Croatia. This is contrary to what was agreed in 1995, when the parties decided that all missing persons who disappeared in Croatia fell within the competence of Croatian authorities, which, for their part, recognized Serbia's interest and role with regard to persons of the Serbian ethnicity. There are other outstanding issues, and these include our request for the return of documents seized by the JNA from the Vukovar hospital in 1991, which are essential for identification of the people removed from the hospital. They are still not delivered. When the President of the Republic of Serbia, Boris Tadic, visited Vukovar in November 2010, a small part of these documents was returned, following which there has been no progress at all. One of the outstanding issues is also the provision of information on the locations of mass graves and individual graves in the territory of the Republic of Croatia, as well as the so-called secondary graves, into which the bodies from primary mass and individual graves were moved, and also the issue of the unmarked graves in Serbia. So the issue of the missing persons remains one of the key problems in these proceedings. Croatia started a campaign with the view to making more discoveries and to help members of the families of the missing persons. As part of the campaign, public meetings are organized in places where information might be available both for the missing Croats and the Serbs. Leaflets and telephone lines are available, inviting people to provide information that would lead to the discovery of these sites. Mr. President, there is no dispute between the parties that serious crimes were perpetrated against the members of the Croat ethnic group, capable of constituting the underlying acts listed in the 5 paragraphs of Article 2 of the Convention, including killings, causing serious bodily and mental harm. The respondent accepts that these acts were committed by members of the JNA and forces associated with it. These acts were widespread and systematic. They caused physical and mental harm and resulted in killings and in the deliberate infliction of conditions of life calculated to bring about physical destruction of groups of ethnic Croats. Article 1 of the Genocide Convention imposes 2 distinct yet connected positive obligations to prevent and to punish genocide. We have set out why the respondent has failed to meet its obligations on both accounts. Mr. President, genocide was committed on the territory of Croatia by or on behalf of the respondent. The evidence of that is conclusive. The respondent, acting through the JNA and other organs of the state, is responsible under international law for those acts of genocide. It is also responsible for having failed to prevent genocide from being committed against ethnic Croats. The applicant has shown that the respondent knew, or should have known, that there was a serious risk that genocide would be committed or was being committed against Croats by paramilitaries. We have given clear examples of that during these proceedings. Moreover, the importance of the obligation in Article 1 of the Genocide Convention to punish acts of genocide is reflected throughout the Convention's provisions. In this case, the respondent has failed to indict and prosecute any of the high-profile military or political figures responsible for the crimes committed. Furthermore, Croatia still demands the return of its cultural properties seized in the course of the genocidal campaign in Croatia. Although some of it has been returned from 2001 to 2013, there are still almost 25,000 items from 45 museums and 1,000 cultural and religious artifacts, as well as a number of private collections, archives, and libraries. Mr. President, members of the Court, Croatia believes that this long-standing dispute between the 2 states should be resolved in accordance with the requirements of the Genocide Convention and international law. This case has great importance for the Croatian people and for the stability and peaceful coexistence in the region. The Court has a role to play, and we permit ourselves to express the hope that it will fulfill its role as guardian of the Convention. And now, this brings me to our concluding submissions. I limit myself today to the submissions in relation to our claim, and on Tuesday, on the 1st of April, I will read out the submissions in relation to the counterclaim brought by Serbia. Excuse me. So, the submissions are as follows. On the basis of the facts and legal arguments presented by the applicant, it respectfully requests the International Court of Justice to adjudge and declare: first, that it has jurisdiction over all the claims raised by the applicant, and there exists no bar to admissibility in respect of any of them. Second, that the respondent is responsible for violations of the Convention on the Prevention and Punishment of the Crime of Genocide. A, in that persons for whose conduct it is responsible committed genocide on the territory of the Republic of Croatia against members of the Croat ethnic group on that territory by killing members of the group, causing deliberate bodily or mental harm to members of the group, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part, imposing measures intended to prevent birth within the group, with the intent to destroy that group in whole or in part, contrary to Article 2 of the Convention. B, in that persons for whose conduct it is responsible conspire to commit the acts of genocide referred to in paragraph A, were complicit in respect of those acts, attempted to commit further such acts of genocide, and incited others to commit such acts contrary to Article 3 of the Convention. C, in that, aware that the acts of genocide referred to in paragraph A were being or would be committed, it failed to take any steps to prevent those acts contrary to Article 1 of the Convention. D, in that it has failed to bring to trial persons within its jurisdiction who are suspected on probable grounds of involvement in the acts of genocide referred to in paragraph A, or in the other acts referred to in paragraph B, and is thus in continuing breach of Articles 1 and 4 of the Convention. E, that it has failed to conduct an effective investigation into the fate of Croatian citizens who are missing as a result of the genocidal acts referred to in paragraphs A and B, and is thus in continuing breach of Articles 1 and 4 of the Convention. Third, that as a consequence of its responsibility for these breaches of the Convention, the respondent is under the following obligations. A, to take immediate and effective steps to submit to trial before the appropriate judicial authority those citizens or other persons within its jurisdiction, including but not limited to the leadership of the JNA during the relevant time period, who are suspected on probable grounds of having committed acts of genocide as referred to in paragraph 1A, or any of the other acts referred to in paragraph 1B, and to ensure that those persons, if convicted, are duly punished for their crimes. B, to provide forthwith to the applicant all information within its possession or control as to the whereabouts of Croatian citizens who are missing as a result of the genocidal acts for which it is responsible, to investigate and generally to cooperate with the authorities of the applicant to jointly ascertain the whereabouts of the said missing persons or their remains. C, forthwith to return to the applicant all remaining items of cultural property within its jurisdiction or control, which were seized in the course of the genocidal acts for which it is responsible. And D, to make reparation to the applicant in its own right and as parens patriae for its citizens for all damage and other loss or harm to person or property or to the economy of Croatia caused by the foregoing violations of international law, in a sum to be determined by the court in the subsequent phase of the proceedings in this case. The applicant reserves the right to introduce to the court a precise evaluation of the damages caused by the acts for which the respondent is held responsible. Thank you, Mr. President, members of the court.
Thank you, Professor Crnić-Grotić. The court takes note of the final submissions, which you have now read on behalf of Croatia on its own claims. The court will meet again on Thursday, 27 March 2014, between 3 p.m. and 6 p.m. to hear Serbia begin the presentation of its second round of oral argument. Thank you. The court is adjourned.